March 7th, 2017. If we could have a call to order, and I can ask the clerk for a roll call, please.
Vice Mayor Narowski.
Here.
Commissioner Dr. Marks. Here. Commissioner Mizrahi.
Here.
Commissioner Shelley.
Here.
Commissioner Weinberg.
Here.
Mr. Soroka.
Here.
Mr. Wolpen. Here. Commissioner Landman and Mayor Weissman are absent. You have quorum.
Thank you. At this time, I'd like to ask Mr. Paul Savage to lead us in the Pledge of Allegiance, so if we could all rise.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all.
Thank you. At this time, I'm going to ask the city manager if there are any deletions or additions to the agenda.
So item G has been removed from the consent agenda and has been added as a quasi-judicial matter at the end of the consent agenda.
Okay. And any members of the commission needing to remove an item from the consent agenda?
Jump the gun. Special. We
Okay.
got special awards first.
At this time, I'd like to ask the city manager to...
The special presentations.
Right, we're going to do the special presentations right now for the Employee Service Awards. So I'll ask the city manager to, and I'll assist with that as well.
Good evening, everyone. It's my pleasure to recognize those employees that have achieved certain milestones with the City of Aventura in terms of service. The first one is Dawn DeJames. Is she here? There she is. Dawn has achieved 10 years of service with the City of Aventura. Next one is Sandra Marquez, 10 years of service. She's currently a detective with the police department.
Thank you.
The next employees have achieved 20 years of service with the City of Aventura. And the other remarkable thing about these employees, and I have them stand when we're done, is that they were part of the first wave of our police department that began 20 years ago on April 1st. So the first one is Sergeant Jeffrey Burns. Please come forward. Sergeant, if you could stay up here, please. The next is Officer Mark Huffman, please. 20 years of service as well. Officer Michael Giordano. Officer Thomas Monday, please come forward. 20 years of service as well. Charles Travis, 20 years of service as well. Is Troy here? Oh, he's on a call, okay. We'll recognize Troy Persina as well as 20 years. And again, I just want to recognize these individuals. 20 years ago, April 1st, 1997, they were one of our first original police officers. Great job, guys. Thank you.
Okay, at this time, I'd like to ask for a motion for approval of the remaining items on the consent agenda. Do I have a motion? Motion by Commissioner Dr. Marks, seconded by Commissioner Shelley. If I could ask the clerk for a roll call vote.
Commissioner Dr. Marks?
Yes.
Commissioner Mizrahi?
Yes.
Commissioner Shelley?
Yes.
Commissioner Weinberg?
Yes.
Vice Mayor Narosky?
Yes.
Commissioner Landman and Mayor Weissman are absent. The motion passes.
Okay, at this time, we have an item that was, At this time, we have an item that was removed from the consent agenda. I believe it was item G. I'd like to ask by having Ms. Carr, if you'd like to present the staff report, or do we do public comment
Yeah,
first?
Mr. Mayor, being this is the quasi-judicial portion of the agenda, I'll read the opening quasi-judicial statement and the resolution, and then the other proceedings will flow from there. This is a resolution of the City Commission of the City of Aventura, Florida, approving the Privé at Island Estates plat, being a replat of land being a part of tracts B and C, 2 islands in Dumfoundling Bay, Plat Book 141, page 66, as recorded in the public records of Miami-Dade County, Florida, together with other lands in Section 2 and 11, Township 52 South, Range 42 East, City of Aventura, providing for an effective date. This is the only quasi-judicial item on the agenda this evening, and this plat item is governed by our quasi-judicial procedures. If any person wishes to object or comment upon this item, you will inform the Vice Mayor when he requests the public input and evidence and comments. An opportunity for persons to speak on this item will be available after the applicant and staff have made their presentations on the item. All testimony, including public testimony and evidence, will be made under oath or affirmation. Additionally, each person who gives testimony may be subject to cross-examination. If a person refuses to be cross-examined or to be sworn, his or her testimony will be given its due weight in accordance with the procedures of the city. The general public will not be permitted to cross-examine witnesses, but the public may request the commission to ask questions of staff directed through the mayor or other witnesses on the behalf of that person. Person representing organizations should present evidence of their authority to speak for that particular organization. Further details of the quasi-judicial procedures may be obtained from the city clerk. At this time, we'd like to ask the city clerk to administer the oath to all persons who desire to offer testimony on this item 5G of the commission agenda.
If you will be speaking on this item, I need you to stand, raise your right hand, excuse me, and be sworn in at this time. If you're going to be speaking on this quasi-judicial item, I need you to raise your right hand. Do you solemnly swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God? Thank you.
Thank you, Vice Mayor.
So at this time, I'm going to ask for a motion for approval of the resolution. Do we have a motion? We'll have a motion by Commissioner Shelley. Do we have a second to the motion? Seconded by Commissioner Mizrahi. At this time, I'd like to ask Ms. Carr, if you would mind discussing the staff report on this item, please.
Thank you, Mr. Vice Mayor. I've been sworn in. I would like to enter the staff report into the record. The applicant, Privé Developers LLC, is requesting final plat approval for a replat of the North Island at Island Estates. And I'll put up a location plan so we can all see where we are. Joanne Carr. Okay. It is the North Island of Island Estates. This is Biscayne Boulevard, the Lehman Causeway, 187th Street, and the islands are accessed by way of 187th Street through private access over Island Boulevard, and then through private bridges and roads to the island. These two islands were originally platted by the owner in 1991, and I'll show you the original plat. The boundary of the island is the oval bulkhead line that you see. Now, since that time, there have been conveyances from the applicant to the state of submerged land and from the state to the applicant of upland, and these are changes that occurred from natural accretion and from permitted stabilization. I'll put up a schematic showing the submerged and upland pieces. So the pieces in yellow are the pieces that were granted or conveyed from the state to the applicant, and the pieces in blue are the pieces that were conveyed from the applicant to the state. And as a result of those conveyances is the new shape of the island, and that is the purpose of the replat. The replat also updates a restriction from a prior county plat in 1961 that's related to development outside of a bulkhead line that was drawn on that 1961 plat when the applicant did not own any portions of the property outside the bulkhead. That restriction is no longer relevant, and that's consistent with the conveyance of those lands from the state to the applicant in 2006, and consistent with Miami-Dade County approval of the tentative plat. The tentative plat was administratively approved by the city on November 23rd, 2015. It was approved by Miami-Dade County on December 11th, 2015, and the county approval is current to June 9th of this year. The final plat has been reviewed by the city's consulting surveyor and by city staff for compliance with Section 3178 of the City Code and Chapter 177 of the Florida statutes, and has been found to comply. The city staff is therefore recommending approval of the final plat. The final plat, as a note, does not change the existing zoning. It does not change any underlying future land use, or does it change the administrative site plan approval. It is a map showing the current boundary of the parcel. And I'll be happy to answer any questions. Before I do, I'd like to introduce the city's consulting surveyor. His name is Doug Davey. He's from the firm of Craven Thompson, and he is the one that reviewed the plat on behalf of the city. Doug.
I reviewed the plat and found it to be in compliant with city statutes and also our city ordinances together with Florida statutes, Chapter 177.
Thank you. At this time, what we're going to do, and I'm sorry, Ms. Carr, did you have some additional information? We are going to open it up for public comment. I understand that there...
Mr. Mayor, sorry, excuse me for interrupting, Vice Mayor. At this time, you would first give the applicant the opportunity to present their petition and then go to the public input.
Stand corrected. If we could ask the applicant to please come forward. And if you could just
Thank you.
State your name for the record. Mr. Price, thank you.
Good evening, Mr. Vice Mayor and members of the City Commission. My name is Stanley Price. I'm with the law firm of Bills and Sundberg, 1450 Brickell Avenue, Suite 2300. Mr. Vice Mayor, let me apologize. When you came over to say hello before, I'm sorry, I did not recognize you.
No hard feelings.
Okay. Tonight, you have a very limited responsibility. You are here to review a final plat. The law in Florida is very well settled that a final plat must be approved by a local government if it meets all of the criteria contained within state statute and in the city code. Section 31-78 is your platting ordinance, and your platting ordinance very interestingly provides that your staff may not put this matter on an agenda until they have verified that we meet all the requirements of the plat. A plat is so well settled in Florida law that it is one of the few instances in which mandamus, which is a legal writ, can be brought against a local government, compelling them to approve a document if it meets all of the technical requirements of the code. Your sole function for those who are opposing this plat is for them to demonstrate how we do not comply with either state law or your local ordinance. Whether they like the project or they don't like the project is irrelevant. Let me have a standing objection, and if any testimony is offered in that regard, the sole criteria for you to look at is whether the technical requirements of the plat have been adhered to. I'd like to leave some time for rebuttal, and I thank you.
Thank you very much. And as this is a quasi-judicial proceeding, I would ask the city attorney if you need to jump in at any point, please feel free to do so.
Thank you, Mr. Vice Mayor.
At this time, we do want to open it up to public comment. I would ask that we do limit the comments to as it relates to the track that we're here to discuss tonight, and also we do try to enforce the 3 minutes per speaker. Obviously, we'll give that a little bit of leniency, but again, please germane to the topic tonight, and we invite anybody who'd like to come speak, just state your name and your address for the record, and we'd like to hear what you have to say. Thank you. Do we have anybody who wishes to speak on the item from the public? Okay.
Thank you, Mr. Vice Mayor. My name is Paul Savage. I'm an attorney with law offices 2121 Ponce de Leon Boulevard, Suite 900 in Coral Gables, Florida. I'm here representing the Island Estates Homeowners Association on this item. I would like to point out that I've had communications with the city attorney, and I'm the one who communicated with him and got this moved onto a quasi-judicial proceeding. And secondly, I've also asked him to recognize my clients as intervening parties or parties with standing. And the city attorney has declined to give me that recognition, but I would say that we are the next adjacent property owner. As your professional staff showed us that great rendering, you really can't get to this subject property without going across our island where we are. And finally, many of the documents that support the plat, and particularly in the opinion of title, which is in the professional staff package, there are many easements and other recorded documents that actually mentioned my client because their rights are inexorably intertwined with one another given the history of the property. So with that, I would like to ask that for some additional time, not much, I take seriously your admonition about sticking to the issue, but I would like recognition as an intervener and some appropriate additional time, more than the 3 minutes.
Please go ahead.
Mr. Vice Mayor, just so the record's clear, I recommend that they not be recognized as a qualified intervener, but they do be allowed to make their presentation as any other member of the public and be allotted additional time, if need be, on the subject.
The record is clear, and please take your time, and we'd like to hear what you have to say.
Thank you so much, Mr. Vice Mayor, and again, I will stay. There's a lot of litigation in this matter, and I promise to stay on the issue of the plat only. My assistant here is going to be handing out a package of documents which go through some of the documents that are principally from your staff file, the review of the plat submittal by the staff tracking your ordinance, the opinion of title, which I'm going to reference.
Excuse me.
Yes.
Mr. Vice Mayor, May I have the courtesy of getting a copy of what's being submitted into evidence?
Mr. Savage, I don't think you have a problem with that.
Absolutely. I would never bring insufficient copies, and Mr. Price is entitled to a copy.
Okay, fantastic. We'll
Absolutely.
make sure that you have a copy, but just going forward, please allow the speaker to finish.
Okay, so as you can see, the documents being handed out, there are several that go to the plat approval. And one of the most important items is behind tab number 3, which is the opinion of title. This is should be in your package. It's in your staff package already. If you look at tab item 3 and the opinion of title and turn to where it says page 4, there starts a list of exceptions that goes through many recorded documents that have to do with this plat. The two that are really relevant tonight are opinion exception number 34, which is an easement, operating, and development agreement, and opinion exception number 29, which is a vested rights determination. The reason why I point out these documents to you, and I see that it's very detailed and somewhat legalistic, is that this plat depicts certain roadways and thoroughfares, and that is part of the city's statutory analysis, that the roadways are as depicted, that there will be ability to access the property, there'll be easements and things. And these items are the subject of hotly contested and active litigation in the circuit courts. And I've said to your city attorney, you're a very smart city attorney, and I'll tell you that I'm not here to argue those cases or to say that my side's going to win necessarily or anything of that nature. What I am here to do is to formally apprise you as a body and as the city government that these items upon which the plat rests, in other words, when your staff went through and checked off that we have these easements, that they are as purported, that they are as listed here on the opinion of title, that we have a vested rights determination, which is the zoning for the whole parcel. Those two items are the subject of two circuit court cases that are moving through the courts right now. So the punchline of my presentation, and I'll have some more remarks, and I appreciate the additional time. But to get to the punchline now, what I'm asking this body to consider is to abate this approval and to defer this item until such time as you have a judgment in the circuit courts that says, oh, these easements that these parties are litigating about, and you're going to be able to access through that island to get to the second island, that's fine according to the judge, great. Or if my side of the case prevails, that easement may not be available. That access, the roadways that are depicted, they may not be available. And I'm not arguing tonight that that's how it's going to go. I'm just formally apprising the council that that's the situation. And analogously, as to vested rights, one of these agreements listed here, or one of these recorded papers, goes to vested rights to zoning. In your staff analysis prepared by your staff, and no one argues that the zoning right now on this parcel is single-family homes. Even Mr. Price will not get up and say that that's not correct. That is the zoning under the code right now. The reason why the high-rise is permitted is that there's a vested rights determination. That is one of these recorded documents. Well, the validity of the vested rights determination is in circuit court, and the cases are moving. One of them has been assigned to the complex litigation division, and that is a judge who does not play around with his docket. He's going to move the case. So these matters are moving, they're occurring, and I think that there should be an end to the development approvals where we're building, we're approving plats, we're giving all these rights so that at the end of the day, you may have an issue where you have a high-rise without zoning for that structure, and you may have a multifamily development without access to the structures if, in fact, the easements and agreements that we're litigating are not valid. These are fundamental depictions that are on the plat. And likewise, I just think that the city will benefit. It will keep itself away from additional exposure to what I foresee to be a huge mess if the circuit court determination should come down on the side of my clients. If they come down on the side of Mr. Price's clients, then we roll the dice and everything, turned out okay. If, however, they come down on the side of my clients, we're just checking these boxes as if they're fine. And I respectfully, and I think that I'm always a big proponent of professional staff. They're the greatest people in the world, including yours. But respectfully, I don't think it is correct to go through your statutory code and check these things off as if they're fine. Oh, do they have that zoning? Yes, no problem. Do they have easements and access and maintenance? One of the code provisions in your code and in your staff documents is, do you have perpetual agreements to maintain these easements and right-of-ways? And, staff checked, yeah, that's fine. You do have that. Well, not if the easements are invalid, not if they're invalidated by the circuit courts. I think you get the gist. These are some legal papers. I won't make you suffer through all of the line by line. I think you get the gist. I've listed here and attached the 2 circuit court cases. And as to the vested rights, which goes to the zoning, just to read something from, this is by a circuit court judge who says that the court found that there is no question that Mr. Price's client possesses vested rights in the property. It's very good news for their side. But then the court says, however, the court finds that there is a genuine issue of material fact as to whether such vested rights extend to building beyond the original intended purpose of single-family homes. And so
Mr. Savage,
yes, sir.
My understanding is that we did have a question for you. I think that at least I am, and we're understanding the preliminary argument, but if you wouldn't mind just to answer maybe a couple of questions, and then does anybody on the commission have a question?
I do, but I have it for the Craven Thompson gentleman.
Okay. If we could have, if we wouldn't mind reserving the right to get you back up here, Mr. Savage.
Sure.
We just have a question, and then we'll get back with you. And I know Mr. Price and maybe some other members of the public also want to comment, so we reserve, just stick around, and we'll come right back to you.
And I promise that, I just have a small piece to go, and I promise it will start with the words "in conclusion." And
It's not going to be a problem, don't worry.
Okay, all right, thank you.
Don't worry, we'll get as much time as you need.
Okay, thank you very much.
If we could have the other gentleman just come and answer a question for us, please.
Yeah, I'd like to ask you a couple of questions in terms of how you derive the plat, et cetera. Could you explain the process? A few questions, so it'll be a process I'd like you to respond to. Please explain first the process you go through in order to do what you did to submit the final plat in terms of title search, et cetera.
The title search is part of the submission package, which includes it goes through tentative plat. And usually that's when you get the first set of title documents from the plat preparer, which would be Fort and Levy and Skiles in this case. So once that's submitted, I go through a checklist of the city's code, along with a checklist of Chapter 177 Florida statutes.
All right, so therefore, what Mr. Savage has discussed tonight and submitted to us here in terms of all these title exceptions, when you're review the plat before you submit it, when you're reviewing title, obviously I'm assuming all this comes up on the title that you've reviewed?
Yes, and I check to make sure it not only affects the plat, but is also plotted on the plat.
So then in your determination, and I'm not asking you for a legal, I'm asking you your determination in the submission package that you put together for the city, you've taken into consideration what Mr. Savage has submitted to us?
I haven't seen that document.
Well, the title exceptions, I'm assuming, just for the moment. The title exceptions, that's all he brought up to us that he wanted us to look at.
I have a copy of the title.
Are there any of those title exceptions that you feel would give us pause to rethink the plat for the moment and grant a request of what he's asking us, or do any of these things not affect the plat, and therefore we would be able to proceed to discuss the plat and the boundary plat itself
So what I'm trying to understand is if any of these issues would be something that we'd want to think about, discuss, or look into further before approving a plat, or are all these things being taken into consideration before you submitted the plat?
You're asking a question of I'm a land surveyor,
Right.
and I think that would be more towards the city attorney.
Okay. David, could you
Yes,
answer that?
the gentleman is correct. The surveyor is correct. There's nothing presented in the title exceptions that would interfere with the plat approval process. The plat approval is a very limited one. It's related to the city code. It doesn't have anything to do with the site plan or other issues. And as to the litigation that is pending, that litigation may be going on for quite some time, as it has already. And there's nothing in that litigation that stops the commission from proceeding in accordance with law at this time.
Thank you. That's answered the question. Thank you very much.
Do any other commissioners have any questions at this time? Okay. If you do have a question, just stop me and we can get answers from whoever it is that we need to ask of. I know, Mr. Savage, did you want to finish what you were saying earlier? Didn't mean to cut you off.
Thank you, Mr. Vice Mayor. I appreciate the additional time. I would like to point out that what your staff did was, I thought, really fantastic. And when your staff reviews one of these plat applications, what they do to make sure that their procedures track the code exactly, they cut and paste the code into a form, and then they use that as their bullet points. And so in the package here, I have Ms. Carr's analysis along those lines. And one of the code-based analysis under Section 31-78, let me see if I get the citation correctly here, 3178 E.
Is this in our package? Should we be following this?
Yeah, sure. If you look at tab number 2, and you'll see some comments by staff. And if you keep turning, you'll get to a paper that says September 15, 2015. There's an application submittal. And if you've caught up to me here, there's a numbered paragraph 5 that says legal documents in draft form ensuring perpetual maintenance of any private roads, parking areas, landscaped areas, drainage systems, wetland mitigation areas, and other common areas. That's one of the requirements that's discussed. And what I wanted to say is, in response to the nice gentleman that did the title work, and in advance of tonight, I spoke to some real estate counsel who are friends of mine. And when you do the title, when you pull the title, yes, these easements and recorded documents will pop up. But until the litigation culminates in a final judgment that's recorded, it's not going to pop up in the opinion of title as part of a standard title search. What I'm suggesting to you is that we need to be not so formulaic and recognize the fortunate or unfortunate fact that there are ongoing litigations, that these easements and these other requirements may in fact be impacted, and that it's a little facile to turn away and just ignore that these court cases may cause all of these assumptions to come into question. So I think you have my point. There are many assumptions and determinations here that if those cases go the other way, or they go the way that we're arguing in another proceeding that I'm not arguing here, that there's going to be a real problem, and that the city should not approve this with formal knowledge of the pendency of the lawsuits. So I think you have my point. I hope that you take it to heart. These are real matters. They will not go on in infinity. They are moving. And I think that it's essential that the city recognize them. Lastly, I will make one last point, which is one of the many myriad requirements here is school concurrency. The city, I think, checks it together with Miami-Dade County School Board. And I did notice, and I'm sure that Ms. Carr can come and educate us, but it seems like the school concurrency under tab 10 and 11, tab number 11, the last paper in my submission here. This school concurrency that's in the file now goes to another project called the Village at Island Estates, which had 148 units. I think it was a prior iteration of the developer's project.
Okay.
And this appears to have expired in December 2015. So I'm a little troubled that if we're checking a box that we have school concurrency, it appears that this is expired. And then if you go to tab 10, immediately preceding, that's the what I believe is the Miami-Dade County checklist. And they wrote, the Miami-Dade County staff wrote, the school board approval is required prior to the final plat, which I think is what we're here to do tonight, is the final plat. So these are details that Ms. Carr may be able to address.
Okay.
But my principal point, and in conclusion, and maybe I have a question from the dais, which I'm happy to take, but my principal point in conclusion is I urge the city to take these litigations, take judicial notice, if you will. You're not judges. Take formal notice of them, and to abate any further development approvals, including this one, until the pendency of the litigation is over.
Thank you. Does anybody have a question for Mr. Savage before we move on?
No.
Okay. Commissioner Landman?
I'd like Ms. Carr to kind of maybe come up and do a follow-up, maybe touch up on some of the things that were discussed.
Mr. Price, if we could ask you to just hang on for 1 second, and we'll recognize Ms. Carr.
Also, Mr. Vice Mayor, if I may, before Mrs. Carr speaks, just to point out that with all the litigation pending that the city's a party to on this matter, none of it challenges the plat. Various other things are challenged, but not the plat.
Thank you.
Okay, if I may address the comment on school concurrency, I have an email on file from Ivan Rodriguez at Miami-Dade Schools. The school concurrency reservation will expire 12/10/15. I have requested an extension for you. Here's the fee to pay. They paid the fee. The reservation was extended, and when I requested the status of this Ford plat review, we had a copy of a letter from the school board saying once a project reaches building permit status, the school concurrency reservation will remain with the project, and there's no longer a requirement for extension. I hope this clarifies the issue. So concurrency was in effect when the building permit was issued, and nothing further was required to be done by the applicant.
Can you comment on the what we have as the last page here of Mr. Savage's document, which I don't know if you have it. He's referencing perhaps a prior project. It's the last document in the presentation.
It was a prior project, but it was updated. That was the first project, Village of Island Estates, 148 units. It was updated when they extended that concurrency.
Okay, thank you. Does anybody have any questions or any comments from Ms. Carr? Mr. Price?
Thank you, Mr. Vice Mayor. Let me give a little more background. Mr. Savage, who I've known for many years, is a very, very nice gentleman. He's apparently new to this case, and I think a little background is necessary, but let me point out that a plat is a preliminary development order, and a plat normally precedes the issuance of a building permit. In this instance, we received 3 development approvals from the city for the foundation permit, for the final building permit, and there was one other permit I just don't remember for the moment. At the time of granting a building permit, you have to pay a school concurrency fee. That's a final development order, not a preliminary development order. And you have to be ensured that school concurrency is in place. We have a final building permit issued by the city. As you were aware by just viewing, the first building is completed, the second building is near completion. So we've already paid the school impact fees. We could not have gotten the building permit without school concurrency. So therefore, the information that Mrs. Savage is relating is not accurate and it's not current. The litigation that's pending deals with a declaratory judgment as to whether we have
Mr.
vested
Price,
rights.
if I could ask that we just keep it to the plat discussion.
Well, I'm rebutting his argument, sir, but I will say that nothing that was disclosed this evening indicates that the staff nor this plat deviates one iota from the requirements of your code. He's asked you, let's make an exception to your code tonight because we have pending litigation. The reality is his pending litigation, even if he's successful, does not accomplish anything he wishes to accomplish. He's asking for a declaration of rights, whether we have vested rights or not. The court's either going to say yes or no. But that's not relevant because we already have our building permit, which was never challenged. And I don't believe they've met their burden under your code or under state law. Thank you, Mr. Vice.
Thank you. Before you sit down, does anybody have any questions for Mr. Price or any comments? At this time, I'd like to ask any other members of the public if they'd like to address the commission. Do we have anybody else from the public who'd like to address the commission at this time? Please come forward. Thank you. If you could just state your name for the record, please.
Thank you. My name is Dara Clark, and thank you so much for allowing me to speak right now. I'm asking for slight leeway. It will relate exactly to the plat as it relates to the advice that you're getting from the city attorney. And so I will try and be as brief as possible while still trying to cite to the authority that I'm using to present my argument. So I will do this as quickly and as expeditiously as possible. And I'm here to talk about Ordinance 2004-12, which is the Ethics Code. And it was enacted to preserve the integrity and excellence of government provided by the City of Aventura. It was essential for the proper conduct and operation of government that public officials be independent and impartial, and that public office not be used for private gain. This is the code that I'm citing to. It's the policy of the city that no officer or employee of the city shall have any interest, financial or otherwise, or incur any obligation of any nature which is substantial conflict with the proper discharge of their duties in the public interest. And I'm citing to section 2-395, subsection 6. And I want to define what an interested person is. It means any person who speaks for or against any resolution or ordinance before the city commission who has a direct financial interest in the action. I'm also going to talk about a business relationship under section 2-395A2.
If I could interject for just a minute.
Yes.
I
will relate it back. It will tie together.
Okay, thank you.
Thank you. Defined business relationship means a member of the commission has a business relationship if they have a relationship with an interested party. It goes further. Section 2-396, certain appearance, work, or payment prohibited. Basically, that section prohibits commissioners from making presentations or getting paid by someone seeking a benefit from the city. That's section 3. 4, no commissioner shall appear in court or as a legal advisor to a party seeking relief from the city. Further restrictions on transactions, section 2-396CI. This is underlined in the code to show how important it is. In the event that during the term of office, a member of the commission grants an application for rezoning, variance, conditional use or zoning code or comprehensive plan amendment upon the application of a person or entity, zoning applicant, no person then serving as a member of the city commission at the time of the city approval shall then and for a period of 2 years after issuance of approval, regardless of whether they are still on the commission, perform any services for or directly accept any financial remuneration, any financial interest in, or any special private gain from the zoning applicant as a result of or in relation to any development which is enabled to occur as a direct consequence of such city approval. These rules are intended to strengthen the faith and confidence of the city's residents in their government.
Mrs. Clark,
Yes.
if I could, are you, is there,
There's a reason.
as it relates to the plat?
As it relates to the plan.
Okay, thank you.
As it relates to the advice that you're getting from your city attorney. What if it's not the commissioners who have a business relationship with the entity, but the people charged with advising the commission? The city attorney signed what was known as a covenant of indemnification on June 1st your city attorney signed this ethics code on 6/1 of '04. On July 10th of 2014, the commission that is not before me today approved a covenant of indemnification at the insistence of Mr. Wolpin and City Manager Soroka. It's supposed to be a legal safeguard for the city when Island Estates brought legal action for issuing a permit for a sidewalk over property and against our wishes. However, it goes much further than that. And I actually have copies for everyone, if you don't mind passing them out.
I'd like us to focus on the
It's
plat, because it seems that you are making some ethical violations, and I'd like the discussion to pertain
going
to
there.
the plat. I think that we're all familiar with, obviously, maybe not the specifics of the code as it regards to ethics, but I think that we all have a basic understanding of what may or may not be kosher, so to speak. So,
But where I'm going with this,
okay.
and I will tie it up, and I'm trying to move as quickly as possible, but the document that was written by Mr. Wolpin and Privé's attorneys, original attorneys, it's a legal contract whereby Weiss Sirota has been paid by Cohen and Privé to fight the lawsuits, and it's spelled out many times, in consideration for the issuance of further approvals and building permits for the proposed multifamily development on the North Island. This is written multiple times within the covenant, within the indemnification, which is more akin
Mr.
to
Vice
a
Mayor?
retainer.
Yes,
As the covenant of indemnification shows, the cone entities are required to indemnify the city for certain attorney's fees and costs related to the North Island development and the prior sidewalk litigation matter. Our law firm bills the city, and the city pays us. Under the covenant, the city has a right to be reimbursed by Mr. Cohn. So checks do flow from Mr. Cohn's entities to the city. We do not do work for Mr. Cohn, we work for the city. And anyone reading the covenant and the procedures used by the city could easily see that. I just wanted that clear in the record to counter these defamatory remarks. Thank you.
thank you for that. And
Vice-
Mrs. Clark, if you could just, again, as it relates to the plat, because it seems as it's a relatively severe allegation, but we're really here to discuss the plat situation, if you could.
Well, this is as it relates to the advice that you are receiving as it relates to the city attorney. I have his deposition, the sworn testimony whereby Mr. Wolpin does talk about the payments to his firm, so I can refute that. It's not defamatory if it's true.
Okay,
So
I understand that. I don't think that it would be appropriate that we have an ethics trial here with regard to this issue. I do appreciate the concerns that you have. If it's not going to be about the plat, we're going to have to conclude the testimony.
Well, my point is, and it is about the plat, is why would the city attorney advise you to do anything if there's anything wrong with the plat? Why shouldn't you worry about the fact that there's pending litigation where the people who bought these apartments will not be able to actually drive to those apartments? You should just completely ignore
To answer your question, Mrs. Clark, and I think that's why we did appreciate that Counsel Mr. Savage is here, as well as Mr. Price on behalf of the developers. We do weigh these issues very carefully, and we have heard what has been said, specifically with regard to the objections made by your attorney, so we don't take it lightly. Again, if you do have something else that you'd like to add with regard to the plat discussion, now would be the time, but if not, I'd like to open it up for anybody else who wants to speak, so just let us know, please.
Well, excuse me for just one moment, but I believe it was on February 13th, and if I could have a moment just to find it, Gary Cohen, one of the principals of Privé, signed a business relationship affidavit stating Affiant does not have a business relationship with any member of the City Commission or any City Advisory Board to which the application will be presented.
Again, I hear your point. We all do hear your point, and we appreciate your point. We do have to limit to the plat discussion, so thank you very much for that. And point taken. I understand what you're saying, and thank you. At this time, I would like to ask any other members of the public if they would like to address the issue specifically with regard to the plat, which is what we're here to discuss tonight. If there are no other members from the public who would like to address this item right now, I'd like to ask any of the commissioners if anybody has any questions or comments at this time. Anybody from the commission? Okay. At this time, I'm going to close this item to public comment. As there are no comments or questions remaining from the commission, I'm going to ask the city clerk for a roll call vote on this item, please.
Commissioner Landman,
No.
Commissioner Dr. Marks,
I'm going to pass for right this minute, if I can. I don't know if I can do that.
I'd like to ask the clerk for a clarification. This is a yay or nay vote, is that correct?
correct.
Mr. Vice Mayor,
Commissioner Weinberg?
can I ask, if it's procedurally okay, can you reopen for a moment? Because I have a question or two that, as it was gelling in my mind before you closed.
Do that?
Mr. Wopen, is that permissible?
Yes.
At this time, we'd like to reopen the item
For commission questions.
for commission question or comment, and we'll recognize Commissioner Weinberg.
Thank you, I appreciate that. I wanted to really, I guess my question is directed to the city attorney, and I want to make sure that I have an understanding, and I guess in my mind, with the difficulty that I'm having, I am imagining that other elected officials may be going through the same mental gyrations, because this is very complex and we're not really in the loop, so to speak, because as I understand it, we're here on a very limited agenda item, but we're hearing a lot of background and a lot of things about ongoing that we're not normally privy to. So you can correct me if I'm wrong, and then maybe that will help everyone to understand better, because especially me. So I heard at the beginning that pursuant to state law, if what we have been presented, the scenario we have been presented for plat approval, given those facts, pursuant to state law, we as a commission must approve the plat amendment. Is that accurate?
That's correct, based on not only state law, but the city code, section 3178. Unless you could find that the city code is not complied with, you have to approve this. Otherwise, it will be reversed by a court in a fashion quicker than President Trump sends out a tweet.
So based on the administrative recommendation that I have received as a commissioner, and based on the advice of counsel that I have received from City Council as a commissioner, I don't think that I actually have a choice pursuant to state law other than to approve the plat amendment. That is what I am understanding. Please correct me if I'm wrong.
Oh, that's correct, based on the evidence submitted and the provisions of section 3178 of the city code, which section says right at the opening that it's designed to implement Florida Statute 177, which is the platting statute. And the plat, as you see, is a drawing. The drawing for the plat doesn't even show or need to show the substantial high-rise buildings already erected on that land. It merely describes the land. It has various monument and markers so that this plat could be referred to in the future for conveyances and other purposes.
So if this commission denied the amendment, is there exposure potentially to the taxpayers of the city?
Yes, there would be exposure because the city has to comply with law. We all cannot refuse a plat simply because we don't like it or may not like it. We have to be able to point to criteria, and the criteria is set forth very carefully in the staff report, and you've heard from the city staff and the surveyor that a very substantial amount of work is done before the plat is submitted for final approval.
Okay. So, to my mind, we're here to vote, but in actuality, we don't have a choice. I mean, it seems like it would be a breach of fiduciary duty. There's obviously always a record of these meetings. In addition, there's a court reporter here, and the advice I'm receiving is I have to vote for this. I think I understand the argument being made by counsel for, I guess it's the plaintiffs in the ongoing litigation, and I appreciate that, and I will tell you that I think if I was a good enough attorney, I would be making the same arguments and trying to do the same thing, but it seems to me, and again, it's outside the scope of why we're here, and that they will win or lose on the merits of their case, independent of what it is that we basically have to do here tonight, and I don't know that we can insert ourselves, even if we wanted to, into that ongoing dispute. It doesn't even seem like I have the right to abate, I believe was the term used by counsel. I couldn't do that if I wanted to, because I would be jeopardizing, there would be a potential exposure to the citizens of the taxpayers of Aventura. So it is a very difficult situation, because I don't think in one way it's simple, but in another way, I've never been here before actually being told that I actually, as a matter of law, have to vote a certain way. That's, to me, as an attorney, that's very strange, because if that's the case, then why is it even before us if it's something why can't it be handled administratively? And just for the record, everything with regard to this matter has been handled administratively. You know, for all the talk that you hear, I actually saw a notice in my elevator in my condominium that said the commissioners have turned their back on us, and this is zoned single family, and the commission's not doing their job. Nothing regarding this particular development has ever been on the agenda of this commission or any commission in Aventura that I'm aware of, because it's all been handled administratively. We've never had a choice to say yes or no. And it looks like we don't have that choice again, because, as I think the record's now clear, I'm being told I have to vote yes. But anyway, my questions have been answered, and I don't know if anyone else's are, but...
Commissioner Shelley, did you have a question or comment?
Yeah, it's just a comment. From what I'm hearing from you, David, and what I've heard from the attorneys, we do have a choice, Howard. If we found grounds tonight that would give us the ability to question what we're approving, we could vote against it. But what we're hearing tonight from our city attorney and from the presentations is nothing pertaining to the lawsuit. The litigation has anything to do with what we're here to vote on tonight. What we're here to do tonight, as I'm hearing from Joanne, is a boundary plat. Is that correct? And it's a meets and bounds boundary plat that's taking care of a piece of property, having nothing to do with what's being built on that property, nothing to do with easements, nothing to do with any of the other issues that we're listening to tonight. So unless I'm incorrect about that, that is what makes it simple for this evening's vote. And we understand what's going on with litigation. Believe me, we understand. But that's not what we're listening to tonight. That shouldn't be a factor. What should be a factor, whether we agree or not, is does the boundary plat meet its approval? And from what I'm hearing from Craven Thompson, he's done his homework. He did his title search. He gave us the documents that we needed. Joanne Carr has approved these documents and said that they're in compliance. The city attorney has said they're in compliance. So we have nothing to refute what we've been listening to tonight. Is that correct, David?
That's correct. In order to deny this, you'd have to find that some of the criteria of Section 3178 of the City Code are not met.
Thank you.
Commissioner Lamman, did you have a question or comment?
Thank you. Tonight we've been presented a brand new package I don't feel comfortable voting yes until I'm able to review these documents. And I understand what the city attorney is saying. I understand what we've heard, but I've just been handed this today and I need a chance to review. So I don't know if it's something that we defer the item. I don't know if it's, what the best way to go about, but I don't feel comfortable if somebody's coming and handing me documentation. I feel the need to take a look at it, go through it, and from there, then I can make my decision and maybe meet again with staff and revisit all of the things that we're discussing. And I know some of it all of this packet, from what the attorney is saying, pertains to the plat. So I feel that I need time to just review this document, be comfortable with it, and then move forward. And that's why my vote was no, because I can't, just be handed something and go forth without reviewing it.
Mr. Vice Mayor?
Yes.
Just if I may, in that regards, City Code Section 3437F says that if a person desires to present documentary evidence at a hearing such as this, they're supposed to, quote, "A copy shall be made available to the commission and to the staff no later than 2 days prior to the hearing on the application." The council, the attorney presented this material just this evening, so that clearly doesn't comply with our code provision. So that failure should not be held against the applicant. The applicant is not the one who presented the packet at the last minute.
Understood. Thank you. Anybody else with a question or comment on the commission? Okay. At this time, we're going to close the question and comments from the commission, and we'd like to ask the city clerk for a roll call vote, and commissioners will be voting yea or nay on this item. Thank you.
Commissioner Landman,
No.
Commissioner Dr. Marks,
Yes.
Commissioner Mizrahi,
Yes.
Commissioner Shelley,
Yes.
Commissioner Weinberg,
Yes.
Vice Mayor Narosky.
Yes.
Mayor Weissman is absent. The motion passes.
Thank you. If there are those wishing to leave the auditorium, we're going to take about a 30-second time period to allow folks to leave before we continue with our agenda.
But you know what I don't understand is that it's just a plot. It has nothing to do, it's very simple.
At this time, as we ask that folks, if you are going to leave, please do so quickly and quietly. We're going to ask our Miami-Dade County Commissioner, Sally Heyman, to please address the commission and the community. Commissioner Heyman, are you with us? Okay. Fantastic. If we could ask Commissioner Heyman to address us, please come on down. And Commissioner, if you would just maybe give us another 30 seconds to allow the folks to gather up. And we appreciate everybody who came tonight. Thank you very much. Of course, all are welcome to stay until the conclusion of the meeting, and we do have some important announcements. Okay. All right, Commissioner Heyman, the floor is yours.
Thank you, Mr. Vice Mayor and council members and staff. I thought this was a packed chamber for me, but I'm glad to be here and put a couple things on the record. It's good to see all of you. A quick update, if I may, for a couple issues in which our relationship, county and municipality, are intertwined. To the terraces of Turnberry, there was a reparation done on an area involving their property, and it was damaged. And the county has begun making repairs on what they damaged and to additional damage that occurred from others. We've assumed the responsibility, and it's being done as far as repairs go timely. Last month we did a gun buyback, and for the fourth year, City of Aventura has partnered with Miami-Dade County and North Miami in our efforts to underwrite this by providing police manpower. And the success is in the volume of handguns and rifles and other weaponry that has been turned in. It's taken off the street, and all of it's being processed at a foundry to become manhole covers, if you could believe. But thank you to the City of Aventura, Mr. Manager. The other thing is civil citations. This city adopted the initiative that I brought here to limit the arrests for nonviolent, non-engaging, annoying misdemeanors. So one, it would save people from being in a situation of having an arrest and being compromised because of that. But the other thing was the efficiency to your law enforcement department and the consequences therein of having to go to TGK, book somebody, only to have a withhold or a null pros by our state attorney's office, and then court and everything else.
May I ask a question about that?
Yes.
If I could. What type of offenses are we referring to here?
Fishing off a bridge, open container, we're talking a simple possession, not use, but simple possession of marijuana, all misdemeanors that really don't involve engagement with another person. Sitting on bread baskets, taking containers from the back of a retail store, such as egg crates and such that become students' bookshelves, those type of things, panhandling and such. It gave literally police departments one other level of discretion. Arrest, do nothing, and now it's civil citation, and they get some of the money back. And with that, I want to thank Major Skip Washoff. He now chairs the Day Chiefs, and he's been a strong advocate for better efficiency in law enforcement. Which brings me to the last item connected with that. You've seen the interaction at County Hall and across the country on the immigration process or lack thereof. Miami-Dade County, and I gave your city attorney a copy of our resolution. I want to make it clear because not only is Aventura an important venue as far as my district goes, countywide, not only for shopping, but for work, for play, for living. It is also the Northeast Dade bus transit hub. So the connectability of people coming and going, especially wage earners that service retail and hotels and such, is important. And we are seeing a great concern and fear in the community for fear that they may be pulled off buses or stopped for no reason and being confronted on their immigration status. That does not exist. The resolution your attorney has spells it out. It is only people who commit a crime that are subsequently arrested and booked at TGK and processed at a federal level through NCIC and determined they are immigrants here unlawfully. Then their names and their identity will be conveyed over to ICE for possible detainer. So for the law-abiding people, the commuters, the residents, the workers of our community, if they are law-abiding, back to the priority of public safety, they have not only a worry, but if this can initiate some calm. I have confidence in this police department here in Aventura, as well as the other ones across the county and Miami-Dade County itself, to do the right thing with probable cause. That dictates an arrest, and probable cause dictates detainer. So for that, I want hopefully a little bit of calm, because we're not getting it relayed in the media.
Can we ask a question? Commissioner
Please.
Shelley has a question.
Yeah, maybe you could explain, and it may not be the moment to do it, but I'm curious. I know when the president changed some of the safe haven cities, so to speak, like San Francisco, whatever, our mayor came out of Dade County and said that he's going to abide by the president's wishes. Were we, and are we not now, or aren't we a safe haven, so to speak, for immigrants? Could you explain and give us an update on what that really what happened?
Briefly, I can tell you, I don't know about the term safe haven as much as sanctuary jurisdiction. I have challenged that term since February of 2016 because it is undefined by Webster and by black letter law. And my concern at that time was to be designated or labeled without clear definition. And people kept saying, don't worry, under this administration or perhaps the next one. Well, after the election, the worry was on. And after the executive order, the urgency was there because based on statements made, it would only affect us adversely. So to the mayor's statement that said, we are going to detain, if I could tell you all, we have always detained. But it was only people who were engaged in an act of criminal activity, brought to law enforcement attention, brought to the detention facility that the county runs, and then their immigration status conveyed. It wasn't a witch hunt, and it wasn't people off the streets. So I'll refute that we've ever been anything but concerned about human rights and for the public safety. Take the bad ones off the street, and if it's an immigration situation, pass it on. I'm just telling you the status right now is there is no overt effort by any law enforcement department, including not only Aventura, but any of the others in Dade County, to go out and search people out. It's once a crime is committed, they're caught and detained at our facility, then the information is processed for the federal government. Lastly, if I might, I want to acknowledge and thank the City of Aventura. They were the first to step up years ago on a plan to do alternatives to get people out of their car. We had the FEC Corridor Coalition between Dade, Broward, and Palm Beach, and given intra-county options for transporting people on our FEC rail. That sort of went by the wayside, but it is reinvigorated and on track, if you might. We have 6 SMART plans, and for some of us in the county, we're promoting it as the number one to move forward with. Financially, it makes the most sense, and for the 4 to 6 stops from the county line here in Aventura all the way to the government center, at least 3 principals are on deck to underwrite it themselves. One of them, of course, is our site here in Aventura, joining with us earlier to make this a Northeast Dade transportation hub with our buses. Conveyed the intent to move people around regionally, along with the Sofers, the mall, and of course the city. You all have stepped up and said, we'd like to have it easier for people to come into our municipality without being in the cars, especially during the heavy season, but most especially to move the people from here down to the Arsht, over to the Heat, down to the PAM, down to the government center, the port, the airport, and everything else that will prevail on connectability. So the time is now, and I'm here to ask the city at a soon future commission meeting to put together a resolution of support saying the city's intent to support not only with your action, but promote it for something to move ahead. This is going to be one of the sure stop planned sites to get this thing going, and I look forward to
If we could, I
doing
believe,
it in our lifetime, let alone your term.
Commissioner Lamb, I believe you have some questions or comments.
Hi, Commissioner. How are you?
I'm good. It's good to see you.
Do you have any sort of timeline for rail, for commuter rail? Our community, our commission has been very supportive and vocal about this is something that we need. So,
what is exciting is we logistically, the people who know transit downtown are saying it could happen in 2 years if pieces fall into place that are moving parts right now. 98.7 or 97.8% of what is needed for a separate line track along the FEC corridor is there, and you're seeing the reparation being done now. The second thing is we have major stakeholders, including the Sofers up here with the mall and the city, and 2 other places where we have private development that will finance the stop and the infrastructure. It's a matter of putting it together, getting the new buyers of the FEC track on board. And this is the cheapest of them. It's projected to come in at $100 $186 million. So it's called low-hanging fruit for the half penny and get the people re-engaged. So hopefully it stays number one.
Anybody else have any questions or comments for our commissioner? And were there any other items? I don't know. I mean,
No, I think this
okay.
touches.
Thank
it's
you
a great
very much.
Thank you, and
No, we
glad to be a
appreciate
partner.
it, and it's nice that you periodically drop in and let us know, because at times we do feel a little bit, up in our little corner here, so it's good to know what's going on at
But
the
it's
county
one
level.
of the best corners of the county.
Agree to agree. Thank you so much for
Thank
coming.
you all.
Thank you.
Take care.
Okay, at this time, I'm going to ask the city attorney to read the procedures for our next agenda item, which is a quasi-judicial hearing.
Yeah, we're up to item 7, ordinances. First reading, public hearing. An ordinance of the City Commission of the City of Aventura, Florida, amending ordinance number 2016-13, which ordinance adopted a budget for the 2016-2017 fiscal year by revising the 2016-2017 fiscal year operating and capital budget as outlined in Exhibit A attached hereto, authorizing the city manager to do all things necessary to carry out the aims of this ordinance and providing for an effective date. First reading of the proposed ordinance.
Thank you. If I could ask for a motion for approval of the ordinance on first reading.
So moved.
We have a motion by Commissioner Dr. Marks. Do I have a second? Seconded by Commissioner Landman. And if I could ask the city manager to review the ordinance, please.
Yes, thank you. This is a mid-year budget ordinance amendment, amending the fiscal year we're currently in, which is the 16-17 fiscal year. And basically, now that the audit is complete, what this ordinance does, it recognizes the carryover amounts that were approved as part of the audit. It also recognizes projects that weren't completed in the prior fiscal year, and they're being carried over to this fiscal year. It also provides funding for the 2 acres that we're purchasing from Gulfstream to amend the budget for that amount. It also provides fundings for the extension of the Silver route for the shuttle bus that we recently approved at a workshop meeting. And as I said before, the majority of the projects contained in here are projects that were funded in the prior fiscal year but not complete, and they're being brought forward.
Thank you very much. At this time, I'd like to open the item for public comment. Anybody from the public have anything they'd like to speak on with regard to this item? It appears that nobody from the public has anything to say on this item. We're then going to close it for public comment. Does anybody from the commission have any questions or comments on this item? No questions or comments on this item. We're going to go ahead and close this item to comment. I'm going to ask the city clerk for a roll call vote, please.
Commissioner Landman,
Yes.
Commissioner Dr. Marks,
Yes.
Commissioner Mizrahi,
Yes.
Commissioner Shelley.
Yes.
Commissioner Weinberg,
Yes.
Vice Mayor Narodsky.
Yes.
Mayor Weissman is absent. The motion passes on first reading.
Thank you. Agenda item number 8. I'm going to ask the city attorney to read the ordinance to be considered for second reading, please.
Thank you, Vice Mayor. An ordinance of the City of Aventura, Florida, creating Division 7 Youth Advisory Board of Article 3 Advisory Boards of Chapter 2 Administration of the City Code of the City of Aventura, Florida, establishing an advisory board and providing for its duties and responsibilities, providing for severability, providing for inclusion in code, providing for an effective date. Final reading of the proposed ordinance.
Thank you. If I could ask for a motion for approval of the ordinance in second and final reading.
Motion.
We'll give the motion to Commissioner Shelley, and do I have a second?
Second.
Second by Commissioner Landman. At this time, I'd like to ask any members of the public if you'd like to address the commission on this item. Seeing that there are no members of the public wishing to address the item, we're going to close the item for public comment. Do any members of the commission have any questions or comments? No questions or comments from the commission. We're going to close the question and comment period. If I could ask the city clerk for a roll call vote, please.
Commissioner Landman,
Yes.
Commissioner Dr. Marks,
Yes.
Commissioner Mizrahi,
Yes.
Commissioner Shelley.
Yes.
Commissioner Weinberg,
Yes.
Vice Mayor Narodsky.
Yes.
Mayor Weissman is absent. The motion passes on second and final reading.
Thank you. There are no resolutions or public hearings, so we're going to go to reports, which we were just treated to a report by Commissioner Shelley. At this time, I'd like to ask, by Commissioner Heyman, County Commissioner Heyman. But although, Commissioner Shelley, if you do have any reports, now would be the time to. Does anybody from the commission, Commissioner Landman?
Yes. I just want to bring up two wonderful events that we had in the past few weeks. We had the Ride with Aventura Police, which I attended. It was a great event. It was a great opportunity to interact with our police force. We had about 480 people there, so I do want to commend our police force for putting that event on, and I hope that it will be the first of many. And then last Saturday night, we had movie night, which broke a record. I was also in attendance. It was perfect weather for it. We had more than 1,700 people there, and we do have a movie night coming up in April. You can remind me, City Manager,
I believe the date is April 1st.
April 1st at Founders Park, and there's a great movie also scheduled for that. But in the meantime, we have another event this Saturday coming up, the Arts, Crafts, and Jazz Festival, and it will be probably another great event from noon to 5. There's going to be live music, arts, crafts, food, family fun, and so we hope that our residents will take advantage of all of these opportunities that we're providing for people to be outdoors, interacting with other community members, and enjoying the amazing facilities that we have to offer for everyone in our community.
Thank you, Commissioner Dr. Marks.
Yes, I had the pleasure of attending ACES this past week, and ACES has received a grant for helping young boys in middle school to learn how to be proper men and use character and so on and so forth. And it was extremely well done. The boys spoke extemporaneously and did it beautifully, and really congratulations to the principal and to Eric, who I know works very closely with the school, and to all of the children there and the staff. It was wonderful.
Thank you. Anybody else?
We have our student from Crop here tonight.
Oh, yeah, it's very exciting. Come on down. Good news only, right?
Good news only. Alrighty. Thank you so much for allowing me to speak once again. For those of you who don't know me, my name is Nathaniel Manor. I am the Vice President of the Student Body Student Government Organization at Dr. Michael M. Crop Senior High. And I am the crop representative for the city to come and enlighten you all on some of the advancements that crop has been going through for the past month since last meeting, some of the accomplishments we've had, and some of the events that we've had and that are coming up. So I guess I'll start off from where I was last meeting. Since then, we've had our JROTC drill teams qualify for the state championships, which took place this past weekend. And out of the best 21 teams in the entire state, we actually received the second place award for our unarmed regulation drill and fourth place for our armed exhibition. And in our speech and debate association, we've had two state semifinalists in speech and debate who excelled in their state championship last weekend in Pensacola. Actually, this weekend, I'm sorry, in Pensacola. And the past weekend, we hosted, for the first time in over a decade at Crop, a CFL, which is one of the local tournaments that is open to all speech and debaters in the South Florida region. So we hosted close to 900 people at Crop for the first time in over a decade. And I know it's unfortunate that Madam Mayor is not here, but she was very active in the speech and debate club as a high schooler, and she knows very well our legacy of success at Crop with speech and debate. So for the first time in a decade, we've hosted a tournament which was incredibly successful and went off without a hitch. And furthermore, in academics, 2 of Miami-Dade's 6 students were chosen to compete at the International Science and Engineering Fair held in Los Angeles, and 2 of those were from Crop. And we've also had Coca-Cola regional semifinalists for that scholarship, which is one of the most prestigious scholarships you can get. It's a $20,000 grant to any school that you apply for, and one of which was from Crop, one of my good friends. And our culinary students won second place at the Taste of Education culinary competition. And our 6 choral students who were excelling to the superintendent's honor choir earned superior ratings and advanced to their own state competition. And since I was here, we've had a couple more notable college acceptances to Vanderbilt University, to University of Washington in St. Louis, to Columbia University, to Tufts University, University of Michigan, and a couple others. And in looking ahead a little bit, next week we have something that is called International Week, which is one of our biggest prides that we hold very dear at Crop, where we have over 30 nations represented, given that Crop is one of the most diverse schools in all of the county. 30 nations are represented, where we have students from every single nation, from their own heritage, come bring a set of culture, whether it be music, whether it be food, whether it be some sort of a live experience, to all students at Crop during both of our lunches. In our patios, we have little tables, and it's actually a fantastic event that I take part in every single year, so I'm very excited for that one. And everyone is very excited, and we've expanded to a week instead of a day. We've actually started our hiring process with a couple new teachers and some security guards to ease some of the problems that we've had in the past. And we've been going to our feeder pattern schools. ACES is one of them, where we spoke to our 8th graders that are supposedly coming to Crop, hopefully, which was an incredible experience. And we've also begun the expansion of our school into the iPrep Academy, which will host an additional 500 to 700 students, and scheduled hopefully to open in the next school year, which is probably the biggest advancement that Crop has had in a very, very long time. This will open up the doors to a different set of students into more of a technology-driven aspect, which was supposed to open by the Highland Oaks area, but was shut down by the housing committee over there because of potential problems with traffic. So
We remember that issue.
yeah, that was a big issue. So we brought that over to Crop, and we're very, very excited for that one to come into play. And of course, our continued success with our 94% graduation rate, 97% of those students moving on to 2- or 4-year colleges, our $90 million that have been given in scholarships over Crop's history to students, our 81 Silver Knight Awards, and of course our top 4% ranking by the U.S. News and World Report. So I'm here to tell you all of this because I wasn't aware that this wasn't common news, but Crop has been going through somewhat of a rough patch. So I'm here to kind of shed a positive light on Crop for those of you who do know Crop and who don't know Crop, and I'm very proud to do that as well. So if any of you have any questions about our school, I'm glad to hear and answer for you, and I thank you for the opportunity.
Thank you very much for coming.
Thank you.
Any other members of the public wish to make any statements or comments? Okay, at this time we're going to close the public comment. Do I have a motion to adjourn this meeting?
Motion.
Moved by Commissioner Landman. Do we have a second? Second by Commissioner Mizrahi. At this time, this meeting is concluded. Thank you, everybody.